so I hope if I turn it on, there we go. So among other things that I did before I went into solo practice, I worked 4 years divisionally attached as counsel to the Child and Family Services Division of DPHHS. So I've actually worked on both sides of the dependent neglect area. A quick poll, and I know the folks online can't participate, but I just would like a real fast show of hands in this room. How many folks here have in some way, shape, or form ever dealt with a child abuse and neglect issue? Cracked open Title 41, counsel, anything like that? Okay, so there are several folks who have. That's awesome. And then how many folks have also done types of family law where you may have had an intersection with issues? So we've got some family law folks too. Okay, and then who's just here for the free CLE? No, that's okay, you don't have to. You can take the fifth. Child abuse and neglect concerns can come up anytime you've got families under stress. And certainly when you do dissolution of marriage, which is something I do in addition to work with DNs, you will find that people sometimes have very legitimate concerns about the other side. Other times, there's just been a total breakdown in trust and their fears run amok. And so if you're ever working with folks in a family law case, realize sometimes it's hard to tell the difference, whether or not they really do have a legitimate fear or if they're just really, really, upset because they're under stress. Poverty, any kind of chronic family system stressor can put families over the edge, certainly trauma and crisis, and sometimes just multi-generational family dysfunction. For some people, things that we now consider to be abuse or neglect have been normal in their family for generations. In criminal law, there's a frequent intersection of child abuse and neglect, particularly with drug cases. We all hear a lot about a meth epidemic, and I would say meth is involved in an overwhelming majority of cases. I took a look at my own caseload right now, and I have open cases involving about 40 children, luckily not 40 families, because there are multiple kids in some of these families. But out of those 40 children that are just on my caseload, I have exactly one case where meth is not involved. And even that one, there's an open question if there's not addiction history. So that's a real big deal and a real big red flag for the potential for abuse or neglect. Family violence often is also correlated to chemical abuse. And then sometimes there's other criminal acts. There are assaults, there are sexual abuse cases, there are all kinds of things where law enforcement may ask CPS to get involved. Folks who work in education, childcare, health professions, religious settings, sports coaches, you work with kids, any of these places, you may come across a child abuse or neglect concern. When child abuse cases go to court outside of just the criminal law system, they usually involve somebody who meets the definition of a person responsible for a child's welfare. And in district court, if they're going to really open up what we call a dependent neglect case or a DN case, that will involve a legal caretaker. That will involve a parent or a legal guardian. So when we start talking about child abuse and neglect, we don't just talk about the random individual, a coach or somebody like that who might injure a child. That tends to fall into the criminal law system. We are talking about caretakers. And the first thing to know about Montana law is that our right to parent, Montana follows the United States Supreme Court that a parent's right to care for their children is a fundamental liberty interest. And we must have fundamentally fair procedures. We must have due process of law. But it's also important to remember that we have Article 2, Section 15 of the Montana Constitution that grants rights to persons not adults. And the Supreme Court over and over and over again, and I'm only citing two cases in particular, where they have pointed out that a child's best interest takes precedence over parental rights. So That's another core concept, and sometimes one that people who may be your clients have to have explained to them. Most child abuse and neglect law is covered in Title 41, Chapter 3 of the Montana Code. However, if you do have a child abuse and neglect matter, here's another list of titles in the MCA that may impact a child abuse case. And so just be aware that there are some side things. If a parent's parental rights are terminated and you're maybe not looking at an adoptive placement, you might be looking at a Title 72 guardianship. If you have a case that you want to dismiss, if they will modify the parenting plan to protect the child, you may have to go into Title 40. Title 42 governs adoption. So there's a lot of cross-fertilization in this area. Now, what I'm going to do is, the talk is going to be in two parts. The first section, I'm going to be talking in general terms for those who don't work in the DN field directly, but in the legal work you do, you may have to be familiar enough with this law to advise your clients appropriately. And then the second half of my talk, I'm going to drill down into the statutes and deliver the information overload that will keep you all wide awake and on the edge of your seat. So, declaration of policy in Montana, child's health and safety, paramount. Family, where possible. Child is entitled to assert the child's rights. We assign attorneys for children in Montana, or at least we have the option to do so. And most of all, underneath it all, children have a right to a healthy and safe childhood in a permanent placement. So at the end of the day, we're trying to protect the next generation and give them a chance to grow up healthy and strong. This world is filled with acronyms. So here's some alphabet soup for you, or perhaps we should call it acronym soup. CAN, child abuse and neglect, several agencies. You'll hear us say CPS as the catch-all for everything. Those of us who go into district court, we say DN a lot because that's the word for dependent neglect, which is often the letter caption of the causes. The term is kind of archaic, but it will never go away, so it's one of the ways that you kind of separate somebody who works at the district court level on child abuse and neglect cases, because folks up at the state, when I worked up at the state, we were, CAN and CPS and CFSD, and then when I started getting to district court, we're CPS, DN. All of this is covered by the Department of Public Health and Human Services, AKA the department. So from here on out, if you hear me say the department, I will be referring to the Child and Family Services Division of the Department of Public Health and Human Services. And then the biggest acronym of all, Youth in Need of Care. You'll hear people even say YINC. That's not some sort of you all use yins. This is YINC. So all of the folks who are attorneys, the first thing you need to know is that you as an attorney are one of the very few people who is not on the mandatory reporter list. You are more likely to be representing somebody who is a mandatory reporter. However, there's no reason that you can't report suspected child abuse or neglect. If you do so, first off, we have 41.3.203, which says you've got protection from liability unless you do something as phenomenally stupid as to make a false report as a litigation strategy. Hopefully, it would go without saying that would not be a real good idea. And your protection from liability is any civil, criminal that might otherwise be incurred or imposed unless you're grossly negligent, bad faith, malicious purpose, or knowingly false information. Under the Montana Attorney Rules of Professional Conduct, obviously, generally our confidentiality, we do not reveal information related to the representation of a client unless the disclosure is permitted by paragraph B, which points one of the exceptions is to prevent reasonably certain death or substantial bodily harm. And our definitions of child abuse and neglect include actual abuse and neglect or unreasonable risk of physical or psychological harm. So in short, most situations, if you feel a question of whether or not you should report child abuse or neglect as an attorney, you may do so in the state of Montana. And if anybody ever has a gray area, you can also call the state bar, and as we like to say, that's a Betsy question. But as a rule, we can report if we want to, but we're not mandated to do so. The list of folks who are mandatory reporters is at 41.3201 subsection 1. It's a long list. The point, though, when you're advising somebody, and especially if you represent employers who are trying to figure out, I run a summer camp, I run a daycare, I run a sports program, what do I do? The reasonable cause to suspect is information that you receive in your professional or official capacity. And it doesn't just include parents, it is anyone. So if people say, well, you know, I think this is happening and I think it might have been this neighbor, it's not the parents, I don't know if I should report. Well, yes, you can report the neighbor, you can report anybody. But if you say, well, you know, I was at the Suds hut and I was having a beer and I overheard people at the other bar stool and they were talking about this appalling thing, is that in your official capacity? Probably not. Could you choose to report it? Up to you. If you report to the Department of Public Health and Human Services. You may also call law enforcement. But keep in mind, if you dial 911 and call law enforcement, that does not necessarily mean that the mandatory reporter has met their duty, which is to report to the department. And I'll give you the hotline phone number here in a minute. Never, ever advise a mandatory reporter not to report. If they're saying, well, I don't know if I should or I don't know if I shouldn't, what do you think? You know, you just say, well, you are a mandatory reporter. Do you have reasonable cause to suspect? Did you receive this information in your professional or official capacity? If you did, the statute probably fits you. And beyond that, we are not psychologists, we are not spiritual advisors, but that's what the law says. It's particularly important if you work with employers to make them aware of 41.3207, which is a statute that I ran into a few times, hearing people say, well, I think a child in my fill-in-the-blank daycare, classroom, sports program is abused or neglected, but I've got to get the permission of the boss, principal, daycare owner before I can report. Anybody who prevents someone from reporting could be subject to criminal penalties. And so if somebody says, well, if I report this, my boss is going to fire me, the boss is in trouble, folks. So it's very important that if you ever do represent an employer or you're ever advising Human Resources Department, boy, you know, certainly if a employer, you know, wants people to say, hey, if you call Child Protective Services, we'd sure like you to let us know. But even there, the identity of reporters is confidential. And so it's really important that employers don't try to control, at least don't try to stop mandatory reporters from doing their job. Protection of reporters, anybody can report, not just a mandatory reporter. The standard is reasonable cause to suspect. The people who report, if you go through the statute at 201, they go through the list of what is required for the best kind of reports. Yes, people can report anonymously. But if the department can't dig up independent, corroborative, and attributable information within 48 hours, they close it and they're done. They can't do any more. If you are a reporter, your identity is supposed to be kept confidential, and unauthorized disclosure could be charged as a misdemeanor. That said, and this is something where a lot of people who work on the court side, on the county attorney side, on the prosecution side forget, if you need that reporter to make your case and they have to testify in court, it's possible their identity as a reporter will wind up being disclosed. And certainly If you call in abuse or neglect and you want to admit, yeah, I called it in, I'm the reporter, that's okay. There's nothing stopping you from saying, yeah, I admit I called it in. That said, you probably don't want to be saying that on Facebook. If a criminal case is open, there may be different laws that apply that trump those of 41.3. And the normal discovery that's made available in a dependent neglect matter, even with identities redacted, may provide clues where somebody who knows the situation really well may figure out who it is anyway. Nonetheless, mandatory reporters have to report, and for everybody else, this is the most important key. If you don't know whether you should report or not, report it. And the centralized intake hotline, 1-866-820-5437, and back in the days when we had rotary dial phones, that 5437 used the acronym KIDS. With a report, the centralized intake unit, which is where all these calls come in from all over the state, they have standards by which they will assess your call and your information, and they will determine the priority that it's going to take, how fast they're going to send out an investigator, or if they're going to investigate at all. When people say, well, I don't know if I should call because I don't know if they're going to do anything, I don't know if I'm right or wrong, that's not something you have to worry about, because that's what centralized intake is supposed to do, is to make those assessments. So if you don't take anything else away from this talk, take this slide and embed it on your retina. And remember the hotline phone number. Now, moving on, if you have clients not involved in a dependent neglect matter, but a child abuse issue comes up, be aware that if somebody is reported as a perpetrator of child abuse or neglect, it can have lifetime consequences. May or may not be criminal charges. People may or may not lose custody of their children forever. They may, in some cases, lose custody of not only of their current child, but of any subsequent children, depending on the circumstances. Also be aware, and particularly in family law, and I cannot count the number of times I have had people in dissolution of marriage or parenting plan conflicts ask me if they think the other side is abusing the child and should they report, and so on and so forth. And generally my answer is, if you have reasonable cause to think that there's abuse or neglect, you certainly may call it in. I remind them about that, a false report or a malicious report or grossly negligent report, is not okay. I do point out that suboptimal parenting is not child abuse, so if the kids went to dad and they spent all weekend living on Cheetos and Pepsi, no, that is not child abuse. That's maybe suboptimal parenting, but it's not something you want to get involved, it's not something that CPS will prioritize. And if you involve CPS, the other thing to point out to parents is that they look at both parents, and they're going to look at your whole family in exhaustive, minute detail. And so if you call in the report, the microscope or the magnifying glass will be on you as well as the other parent. Also, if CPS becomes involved when there is an active family law matter, if they take action, that action is going to take precedence. You might have a parenting plan, you might be mediating, you might have an agreement, you might even have a decree. But CPS can override any existing parenting plan while the case is open. Now, once they close it, if they dismiss it, then it'll go back to whatever previous parenting arrangement was made, unless kind of in the middle of it you filed other action. For example, if they say, we'll dismiss this case if you amend the parenting plan to be A, B, C, and D, and in those cases you can have it all drafted, you can have it all filed, and pretty much file the modification simultaneous with the dismissal. When people do have reports of child abuse and neglect, the first thing that the department is going to do is see if somebody has protective capacity. And if one parent can protect the child from whomever else, uncle, cousin, grandparent, other parent, next door neighbor, whoever, the department is not likely to actually get involved. When they might get involved are situations where the parenting plan is such that it's a week on, week off, 50-50, and yeah, one of the parents got busted for meth. Then you may see them involved at least until such time as the child could be placed in such a way that they're safe. Last year we had a case handed down, in Re KB. I was peripherally involved in the district court side of this, not representing the individual who appealed, but some other parties in the case. And at the end of the day, KB stands for the proposition that there really is no such thing as a non-offending parent. Technically, there may be a parent who is protective, but they need help from CPS in order to fully protect the child until there's a parenting plan amended or until other parent gets out of prison or whatever. But KB was a case, if you read it, where a father who was not the person that was the person the case was filed about was given a treatment plan. He didn't like that he had a treatment plan, so they renamed it. They called it something. It was a treatment plan that wasn't called a treatment plan, basically. And he didn't do that either. He just, kind of blew it off, said, I'm the non-offending parent. I don't have to do this. I don't have to do anything. I'm not the one who got busted. And the court disagreed. They said, sorry, Dad, but you had a treatment plan too, and you didn't complete it, and your parental rights are terminated. So, and that was one that came out of Judge Reynolds' court in the 1st Judicial District. And finally, keep in mind that whatever else is going to happen, the parents can work with CPS. They can set up voluntary agreements. And again, CPS may not file a case in district court if they can sit everybody down, come up with a voluntary protective services plan, and it is followed. And that voluntary plan may very well be go to court, modify the parenting plan. Agreement may very well be don't let, Uncle Fuddly babysit the kids anymore. There's a lot of things that as long as parents are protective, CPS might keep their eye on things, but trust me, filing in district court is not their idea of a good time either. So, now we get into the nuts and bolts of how a DN case might work. A call comes in to centralized intake. They decide this is something they have to investigate. They set out a timeline. If it's a priority 1 call, they drop everything and go now. Other levels of priority, they may have to act within 24 or 48 hours, within a week, within 2 weeks. But one way or the other, if they haven't done anything in 60 days, it's closed, it's done, it's gone. But while they're investigating, the authority of CPS is very, very broad. They have a right of access to children in any medical facility, at the hospital, at the doctor's office. They can interview kids at school without parents present, and that's one parents get very, very upset about. They'll say, oh my gosh, that social worker, they came, they pulled my kid out of class, they talked to them at the counselor's office, and I wasn't even called, and I wasn't there. Well, unfortunately for the parent, that's what they can do. That's within their statutory authority. CPS may call law enforcement for assistance. Yes, Child Protective Services is governed by the 4th Amendment, by the 5th Amendment. But the problem is that if people are very uncooperative, then they're going to call law enforcement, then they will get the search warrant, then they will involve even more people. And a complete lack of cooperation under statute can itself become a cause to file a case. The report that CPS writes has to be written, filed with the department. Certain types of reports can be provided to the family upon request. There may be information redacted, reporter names, things like that. This is all in statute if you look at 202. They may seek emergency protection of the child, and if there is a parallel criminal matter, it does not toll the DN case. In fact, sometimes criminal matters can drag out for 2 or 3 years if we have Supreme Court appeals. And in a lot of cases, the children's parental rights will have already been terminated long before the criminal trial even goes to district court. Now, some of the reasons that CPS will file: emergency, severe abuse or neglect, criminal charges of endangering the welfare of children, and that statute has been amended several times and tightened up more and more when there are issues regarding methamphetamine. And it's getting to the point now where pretty much any exposure of children to methamphetamine, not just labs, not just active witnessing, but any kind of exposure to meth can give rise to a criminal charge, and it's a huge problem. High risk to the children, unreasonable risk of physical or psychological harm, physical or psychological abuse or neglect, abandonment, and failure to cooperate. Failure of voluntary efforts. If they give you that voluntary protective service agreement and you still let Uncle Fuddly babysit the kids, you're going to get a case filed. And the department does have a requirement that they make reasonable efforts to prevent removal. And if they do have to remove the child, to have them returned. And if those reasonable efforts fail, again, they may have to go to court. For attorneys, a lot of people wonder about CPS policy. And when I worked for the department, we were still printing out the policy manual, at least in small numbers. It filled a 3-ring binder that was the big thick ones, the big thick 3-4 inch ones. It's a very, very lengthy document, many, many sections, but the whole thing is online, and this is the link for the manual. And so it's not particularly well indexed, and it is not searchable, but it's there, and it is available to the public if you want to know the policies, the internal law that governs child and family services. What really controls the cases at the district court level is statute. Almost all case law are appeals of termination. There's a few other cases on placement issues, post-termination, very, very few interlocutory matters. Most of the time, if you go through the termination of parental rights cases, appeal to the Montana Supreme Court, first off, I haven't crunched the raw numbers, but I'm just looking at the list. 3 out of 4 of them are non-cites, and the non-cite will go very simple. Mom or dad or both did not complete their treatment plan. They did not deal with their methamphetamine addiction. The department, the court did not err in terminating their parental rights. End of story. The details of each individual case will vary, but as you start reading cases and you start reading the fact patterns, what's really sad is how similar they are over and over and over again. The state and the district courts have to be very aware of some federal laws that govern child abuse and neglect cases, and in particularly the statutory timelines. If certain timelines are not followed, the state loses federal funding for these children. And the reason is that they want kids to not be left languishing in the system for years and years and years on end. They want these cases to go quick. This can result in a little bit of a conflict between a parent and their liberty interest in parenting to get the courts to have a determination of what's in the best interest of the child. But be aware that from the second a case is filed in district court, there is a clock that's running. Whenever there is a case filed in district court, the right of counsel attaches in the state of Montana with attorneys assigned by the Office of Public Defender. They are working on policy right now as far as financial tests and indigency, just as they would for criminal law, but they're going to start out giving everybody an attorney and a separate attorney. Mom gets an attorney, dad gets an attorney. If there are multiple children from the same mom with multiple dads, each individual dad gets a different attorney, because all of these interests are not the same. I mean, how many of us know cases where, hey, do mom and dad get along on anything, especially if they never married? Children have to have someone representing them or their best interest. under the statute, under 425 sub 2 sub B, if there is not a guardian ad litem appointed, and those folks usually come through the CASA program, then they have to have an attorney appointed. And it gets a little bit complicated because you can have a child's attorney and a guardian ad litem and an attorney for the guardian ad litem. If the CASA folks, some counties, I think Silver Bow is one of them, they just appoint attorneys to be guardians ad litem. In Lewis and Clark County, they assign CASAs to every single case. I know of a couple of cases right now where CASA has counsel, and then a child's attorney may be appointed for the child regardless of whether there's a CASA involved or not. There's a policy with OPD and in most counties that generally an attorney to represent the child's expressed wishes is not appointed for children under 5, though there are exceptions. I'm one of the exceptions, a couple of cases like that. The purpose of a child's attorney, and there's some handouts out on the table that go into this in a lot of detail, it's kind of controversial whether a child's attorney is advocating for the child's expressed wishes or if even the child's attorney has to advocate for the child's best interest. And in Montana, going back to one of the Rolfe cases, and I think everybody who ever went to law school in Montana, we studied Rolfe 1, Rolfe 2, Rolfe 3. I don't know how many Rolfe cases ultimately were decided before they learned to get along with each other or their children grew up. I don't know which. But there's a lot of case law in the Rolfe series of cases, one of which is that in child custody matters, an attorney appointed for the child is supposed to advocate for the child's best interest. And the court, Montana Supreme Court, in several cases has said on dependent neglect matters, we're going to follow Rolfe and this best interest assignment. However, there is also the issue, and this is why I have the Curry article in your printed materials, there's also the question of a child's attorney making sure that the child's voice is heard. And there is a case that you have the whole thing in your material in Re KH where they make it quite clear that you still do have an obligation to represent what the child wants, what the child said. Doesn't mean you're going to argue for it. You as an attorney, the expression that Andre Curry uses is substituted judgment. You can use your judgment. If the child says, I want to go live with my meth mom and, her biker boyfriend and, go to wherever and do whatever and so on, as a child's attorney, I may have to say to that kid, well, I'm going to tell the court that that's what you want. I wouldn't hold your breath that that's what you're going to get. That's probably not going to be in your best interest. And so in terms of representing a child's expressed wishes, it is very important to let the child's voice be heard. And in doing so, usually you can say that, I'm not going to be filing dispositive motions to let child go back to meth mom when that's a really, really bad idea. But sometimes it may mean that a child's attorney is not always going to agree with the state's case or the parent's case. They may have their own theory of the case, and that is where you as a lawyer have an obligation to use substituted judgment and consult with appropriate people to determine what's really going to work out for a child client. There are standards. There's an ABA model rules on representation of parties in dependent neglect cases, was passed in 2011, and I believe I've either got a link to it or a couple pages of it in the handouts. So again, if you want to take a look at those ABA model rules for attorneys who represent DN clients, I strongly encourage you to do so. Okay, so back to Title 41, some key statutes. The definitions are in 102. There are a lot of them. We have a handout that lists a few of the more interesting and useful ones. 41.3205 governs confidentiality. The confidentiality statutes in Montana are difficult to interpret, and I have seen the interpretation of 205 change depending on which lawyer you're talking to. However, we have the same problem we have throughout Montana constitutional law, that balance between individual right of privacy and public right to know. But for the most part, CPS will start with the assumption that it's all confidential, and then there is a very limited set of circumstances, literally spelled out in an A to Z list, so there's 26 of them with subparts, of when and where and why and how and if some information may be disclosed. I'm listing here the statutes that cover emergency protective services. Title 41, Chapter 3, Part 4 governs basically all of the procedural stuff on child abuse and neglect. This is a very complex chapter, but this is where all the meat is Part 4. Then, if people do not complete treatment plans, if people do not do what they're supposed to do, there is the potential for a termination of the parent-child legal relationship, and that's in Part 6. Finally, for Montana, a lot of our cases will involve the Indian Child Welfare Act, and this will apply from the very beginning of a case, from removal. It's going to kick in. We have Supreme Court precedent going back to 1981 that we recognize how important it is that ICWA be followed. And in Montana, not only do we have the definition of an Indian child as defined in federal statute, which is basically enrolled or eligible for enrollment in a federally recognized tribe, but we also include tribes recognized by the state of Montana, which basically means the little shell. So if you've got a child, in fact, I just was talking to a caseworker about this in the past 12 months. They were saying, well, kid's little shell, I don't think we have to treat it as an ICWA case. And I said, oh, yes, we do. And in fact, when Little Shell was put in, I actually did the initial legislative draft on it, so I remember it very, very clearly. And it was a deliberate decision on the part of the legislature to include the Little Shell tribe. So just another thing about ICWA, one of the reasons I cite MEM, and you can shepherdize that case, in a child abuse and neglect proceeding, ICWA has a higher standard of evidence, higher burden of proof, and if you do not do it right, you will go back and you will do it over. And that is something that whenever people wonder, should we handle this as an ICWA matter or not, a county attorney? I will say, sure. My apologies that we had a little bit of an interruption. If anybody else wants to assist out there, feel free. Moving on, I have a long, long list of federal laws that affect DN cases. I'm not going to go over them, but they're in your materials. And as you can see, a lot of these are tied to funding. that goes to the department and is the funding that helps support children who are in care. And so the biggest one is the Adoption and Safe Families Act. That is where a lot of the timelines for federal law come in, as well as Title 4B and Title 4E of the Social Security Act, which cover a lot of the SSI money that also supports children. ICWA, of course, and HIPAA as far as privacy of any kind of health information. So anyway, there's a ton of them, and you don't have to know every federal law, but just be aware they may impact your cases. Now, when we get a dependent neglect matter, the burden of proof for removal and emergency services is reasonable cause. And when people ask me, could the department do that? Did they have a right to remove my child? I explain, well, it's sort of like when you're driving down the street. Did the police officer have reasons to turn on the red and blue flashing lights? And if they did, you're at reasonable cause. To adjudicate the child as a youth in need of care outside of an ICWA case, the standard is preponderance of the evidence, more probable than not. So remember, DN cases are civil, not criminal proceedings. And when I represent clients, I have a lot of moms and dads who may be familiar with the criminal justice system, and they're going to start holding me to the criminal law standard. I'm saying, no, no, no. It's not beyond reasonable doubt. It is the civil standard of preponderance, more probable than not. Now, the clear and convincing standard, which is preponderance on steroids, basically, is the standard used for termination of parental rights in a non-ICWA case. And if you have an Indian child, to adjudicate that child as a youth in need of care, you also have the higher clear and convincing standard. The beyond reasonable doubt standard, which we use for criminal cases, applies one time in DN matters, and that is termination of parental rights in an ICWA case. So where you have an Indian child, you have to meet a much higher standard in order to terminate those parents' rights. There are also a lot of other statutes dotted throughout the Title 41 where in an ICWA matter you also have to have a qualified expert witness to testify that removal of an Indian child is necessary, that it's in compliance with the cultural child-rearing practices of native children and native people, and so on. Now, a couple of things in the stages of a DN case. I've talked about reasonable efforts. If it's an ICWA case, those are ratcheted up to active efforts. The reasonable efforts one time was described to me by some of the folks who work for Child Protective Services. They said reasonable efforts would be when we give a person a list of counselors and parenting programs that they can contact to get the counseling and parenting classes they need. Active efforts is that they're sitting in the office and I make the call and set up the appointment while they're sitting in the office with me. That's an example. You go a little farther when you've got an ICWA case. On the other hand, and again, the exception is for Indian children, the department may also choose to decide, you know what, we don't need to make reasonable efforts. But they do have to ask the court to make that determination. They can't just willy-nilly do it. They've got to go to court and say, you know, we believe that reasonable efforts do not need to be provided. Most of the time, it's clear and convincing evidence and specific findings that certain bad things have happened. Sexual abuse, aggravated assault. The big one that gets a lot of parents is termination of parental rights of a previous child. That's when a lot of cases, they've got a previous case, previous termination, mom has another baby, CPS is at the hospital, they take custody of the baby at birth and file. And they may also ask for the determination under 423. Now, a normal case, a petition, just like any other legal matter, petition initiates the case. 41.3, 422 is long, it is complicated, and even I have to reread it almost monthly to have the slightest idea of what is in it. It's got all the pieces, but they're not particularly well organized. but that's where all the details for petitions are. I'm also going to say that if you practice in district court, every county is a new world. So Lewis and Clark County has one set of policies. 3rd Judicial District, you go in front of Judge Dayton, he may handle it a little differently. You go to Jefferson County, 5th Judicial District may handle it a little differently. Silverbow, Cascade, Missoula. Each county is kind of its own world, and there are differences in how county attorneys interpret these statutes, and particularly 422. Again, very little case law to guide us on this. There's very few interlocutory motions, and to be honest, the reason for this is bad facts make bad law. Most of the time, when somebody feels that the law hasn't been followed properly, at the end of the day, we still have drug-addicted parents. And so the right case really hasn't come before the court yet. Emergency protective services can be initiated ex parte. The judge will sign the order with the child being removed. There's a number of timelines under which the department has to file their petition and so on. The first legal stage where the parents can get in and give their piece is the show cause hearing. Must be held within 20 days. They have to demonstrate the department has made reasonable efforts. There's several different outcomes of a show cause. Sometimes people will stipulate all the way through. They'll just say, adjudicate this child or youth in need of care. It's like pleading guilty in a criminal case, only under a different evidentiary standard. A lot of times, though, at a show cause hearing, there's been no discovery. There's been preliminary investigation, but there's a lot of things ball still in the air. So a frequent outcome at a show cause is what they call temporary investigative authority, which can go up to 90 days, no more, and a continuation of emergency protective services. Within 90 days of the show cause, or sooner, there does have to be a hearing to determine whether the child is adjudicated as a youth in need of care. And it's really important that this adjudication piece is done. You'll hear social workers say, we want temporary legal custody, TLC. TLC is a dispositional order. It is not a status order. And the department's cases are rarely is the department reversed when they terminate parental rights. And when they are reversed, people really look up and go, wow. And one of those was this case I have cited in Ray BNY 2003 case, where they did not have the evidentiary hearing and find by a preponderance of the evidence that the child was a youth in need of care. They just happened to skip that, went right to TLC, gave the mom a treatment plan. The mom blew off the treatment plan. They terminated her rights, and she said, wait a second. And they went back and looked through, and they went, oh, yeah, we never did have the judicial determination properly done. And so a reverse and remand occurred. After the child is adjudicated, then either same day or within 20 days, there is a dispositional hearing where the court decides what are we going to order the parents and the department to do. And usually they'll get 6 months of TLC. It can be reviewed every 6 months. Most of the time they will order a treatment plan. And the courts have clearly stated that parents must fully comply. And let me underline, fully comply. Over and over and over again, the Montana Supreme Court has said partial compliance doesn't cut it. They did most of it. They tried really hard. Doesn't cut it. They've got to do what's there. And so again, if you have a client coming to you saying, do I have to do the psych eval? Do I have to do the CD eval? Do I have to do this? Do I have to do that? The answer is always, yeah. If it's in the treatment plan, you have to do it. If you think it's unreasonable, sure, we can try some court action. We can see if we can amend the treatment plan. But yes, you have to comply. And most of the paperwork will say, even completing the treatment plan may not guarantee return of the child. And again, we have precedent on that. It is not considered successful unless the parent effectuates the purposes for which the plan was designed. So if they jump through all the hoops, but they still have a lousy attitude and they got overheard saying, yeah, as soon as CPS is out of my life, I'm going to go right back to whatever, you know, that's not going to go over so well for them. There's a couple of deadlines. One is that within 12 months of a statutorily designed starting point, there has to be a permanency plan for the child within a year so that they don't languish in foster care from the age of 4 until they age out at 18. If they don't have a permanency plan, the department can lose the federal 4E funding for that case. So that's very important that everybody pays attention to that 12-month permanency deadline. It's not a gotcha. It doesn't get the case dismissed. It just hurts the child if it's not followed. And then finally, if things go wrong, we have a termination of parental rights. The grounds for termination when it has to be filed are covered by 413604. And it's a rebuttable presumption that if a child has been in an out-of-home placement for 15 of the previous 22 months, termination is in their best interest. The other time that you have a presumption for termination is when the courts have made a determination that reasonable efforts are not required, and that can happen anytime. If you have an abandoned child, they'll be filing for termination 6 months in. Options would include adoption of the child or permanent guardianship, and where the child is placed, we have a 2016 case reminding us all that the court has the discretion to determine placement, and it's in the best interest of the child. The BWS case stood for a situation where 2 different foster families on equal footing as far as, you know, were they all related or not related. They were considered legally equal in the eyes of the law. Both contested custody. One just had this child and had had her since she was very, very small and for many years as the case went on. The other family had the child's siblings. And in this particular case, the court said this child, BWS, will stay with the family with which she had bonded, even though all of her siblings in her family were with the other foster family. And it's, we do see these kind of conflicts from time to time. The nice outcome of a case is if the department can dismiss, and that's under 424. And if, first off, the department can dismiss any time. But if all 3 of these following standards are met, or 4 of them, I'm sorry. No, 3, I'm sorry, I can't read my dots. If all 3 criteria are met under 424, then the department must dismiss. If they're reunited, they're home 6 months with nothing going wrong, and the issues were resolved, they can't just hang on to it forever and ever, which is kind of nice. And we love to see dismissals when they can occur. So that pretty much wraps up my presentation. Just the take-home to remember is that all children have a right to a healthy and safe childhood. So I've got just a few minutes left, and believe it or not, we actually have about 3 minutes for Q&A, so I don't know if anything came in, Sarah, via the web feed. I can answer those first and then talk with folks who are in the room. Okay, great. So any questions from folks here? Yes? I don't know if Kathleen Jenks's flow chart with the timelines is still out there. I was actually going through some, like old PowerPoints and seeing if I saw something like that. I don't know if that graphic still exists, but the timelines have not changed much. It's more the hammer of what will happen if you don't follow them has changed a little bit, but the 20 days for a show cause, 90 days for TIA, 6 months for TLC, permanency within a year, and termination at 15 of 22. Those pretty much have not changed. So, a timeline is lovely because there's overlaps. Yeah. And there also are judicial guidelines if judges are looking for the standards that the courts apply. I did find some material on that, and if you contact Sarah, I think I can send her the link to the judicial content. So if there is anybody in the court system that wants those, we can make them available. I saw another hand. Yes? Okay. I would say, you're, for one thing, talking with the state bar, talking with the folks that are in your area. But let's say, for example, you are an attorney and perhaps you are also employed by an educational institution or you are employed by a healthcare institution. It's important to have first off, I would say when in doubt, just report. Hopefully it won't be a dilemma because you'll just report. And where you think you have a gray area, my gut says the mandatory reporter side has criminal penalties attached to it if you don't report, whereas the attorney side has the rules of professional conduct. And I suspect I would rather go in front of the Office of Disciplinary Counsel than go to jail. So I would say if you're going to split the difference, that's where I would go. That said, I do think it's a conversation that is worth raising, certainly with the bar. But generally, I have seen most attorneys will come and say, if you don't know what to do, report. And that's the bottom line. So. Other questions? Well, we are exactly at 1 o'clock, or about 1:02, so I'll go ahead and wrap up now. And I thank everybody, and I also thank your patience with the interruption we have. I hope all goes well with that. And thank you all for coming.